allowed.
Very long
You
day
wanted
for your
it to be
ladyship.
the first higher up on the list.
I know.
It became on the last.
But
And
actually,
no, before hearing you, and how many of you are on social media? I would like to know. And there has been a smear campaign on the social media, and
very
I'm
unfortunate.
really, yes, I'm really pained by it. I have been maintaining my, I don't know how many of you know what my husband does also, but now there is a imputation that somebody is influencing me, and something is being offered and all that. So,
But I must
it's
actually
very,
bring it to your ladyship's notice. This is not the first time it is happening in this vacation court. On the presumption that one of your ladyship's brother judges is likely to hear the matter, they started the smear campaign against your ladyship's brother judge originally. After the matter comes up before your ladyship, it's again started. But this is where, my lord, they actually try to browbeat the judiciary, and my lord, the Supreme Court has been coming down very heavily. But in fact, these people need to be taken task, and my lord, the matters pending before the Supreme Court, where the police authorities would have to take severe action against these people, because maybe about this case, it may be about some other case. But as I am seeing, increasingly, my lord, if this is not going to be stopped, but I'm glad that the public prosecutor is here. They should take notice, my lord, because what is happening otherwise, my lord, any matter, no matter can be heard in a case, in a state of, my lord, complete independence and fearlessness by the judiciary, my lord. Because anything and everything, every matter comes up that is sensitive, my lord, they start this. I'm not making any allegations against any person. I think we as bar, my lord, we have to stand up that this has to stop somewhere. But my lord, I only request I would make is, my lord, that eventually your lordships always operate, my lord, independently. But I understand, my lord, it's really painful. My lord, I also saw some part of it today in the afternoon. One of my colleagues showed. I said, no, please don't even show this to me. But since it has reached your ladyship, my lord, I thought it was my responsibility to bring it to your ladyship's notice that this is a smear campaign that started 3 days before the vacation courts were to sit, anticipating this matter will come before some other judge.
no, and that's why I want.
Milad, morning itself, I saw this pamphlet, like WhatsApp.
It's
Milad.
not pamphlet. I think
WhatsApp,
it's on the
through
social,
WhatsApp,
social media.
Milad.
Some unknown person
Yes, Milad.
making some comment.
Today afternoon,
Yes.
Milad, I informed today, Milad, Hyderabad CP about this incident. Milad, he is taking some action, Milad.
Yes, it should be taken.
Yes.
No, I'm not shying away from hearing this matter, and
Well,
I'll pass orders. But this is not done. This is not the way you smear the judges, try to intimidate them, saying that if you do this, you will be accused of this. It's not done.
Milad,
It's
whatever
not.
is circulated through the WhatsApp, Milad, all the same thing forwarded to the land CP, Milad, Hyderabad CP. Milad, he assured that he is going to be taking the action.
No, but then I would like to know from the respondent victims counsel if he has any reservations of arguing the case before me. If you have, then yes, I will not hear the case any further. But if both of you repose confidence in the court, yes, I will proceed. Otherwise, I will not.
Your Lordship may kindly hear me, my lord. These things are a passing phase, my lord, and these things do happen, my lord. Now it's become a common norm. So, my respective submission is, my lord, your Lordship may kindly hear the matter, my lord. I have no any reservations.
Very.
That will reassemble in 5 minutes.
Yes,
It has been a long day. Yes. Yes, sir. Mm.
But if I may, with your ladyship's permission, just place a few facets because your ladyship wanted to hear, my lord, the victim in relation to the interim prayer that we were making. So yesterday, my lord, I had placed your ladyship's kind consideration that this concept of granting an interim relief in an anticipatory bail, including in a POCSO case, where serious allegations of Section 6 are made, are not foreign, my lord, to the Indian legal context. But I don't need to cite all of these judgments. What I have done, my lord, very quickly for your ladyship's quick convenience, I'm passing on copies, my lord, to my learned friends also. In one place, if your ladyship just sees, my lord, the top of the sheet itself, my lord, under the first heading, I had mentioned, my lord, that the court's hearing bail petition has an inherent power to grant interim bail pending final disposal of the bail application. Well settled principle. I've placed 3 judgments. I've given the paragraph numbers. I note it. I don't need to trouble and show it to your ladyship.
Yes.
Lord, under the second proposition, my lord, I have specifically referred to cases granting interim anticipatory bail, interim protection for POCSO offences. My lord, 4, 5, 6 I gave yesterday to your ladyship.
Yes.
My lord, what I have indicated, my lord, is under the citation, that SLP numbers, your ladyship would see I had given the sections also under which, my lord, these cases were filed. First one is under Section 6, second one is under Section 6, third one is under Section 6, my lord, at serial number 7 is under Section 12 POCSO along with 75 BNS. My lord, serial number 8 is Section 376 and Section 4 POCSO. My lord, these are all judgments of the Supreme Court, my lord, from 4 to 8. 9 to 11 are the judgments of other high courts, my lord, where they have granted interim protection. So, my lord, eventually, in law, the power is always available, including under POCSO cases. It will turn, as your ladyship correctly put it yesterday, on the facts of each case. So, very quickly, I'll demonstrate my case by your ladyship's kind consideration for granting me interim protection. Now, if I may start, my lord, with the complaint itself that was placed, my lord, before the police, on the basis of which FIR is registered. If my ladyship may kindly permit me to go up to page 16, where the complaint starts.
Yes.
But before I just read some relevant parts of this, my lord, I'll be mindful that this relates to a very sensitive issue. But it is my duty as a senior counsel to place the facts and law as fairly as possible and assist your lordships, my lord, in a matter like this, because whatever your ladyship would decide, my lord, would be chartering, my lord, at least in relation to this Telangana High Court, my lord, a course of action that needs to be followed in POCSO, which by its very nature is, my lord, a slightly serious enactment meant to curtail certain mischief. My lord, as I will read through this complaint, I'll place for your ladyships very quickly a gist and then show these parts, my lord. Complaint states, my lord, that the mother as a victim is filing a complaint saying that the mother came to learn that the daughter who is under the age of 18 years, and I will take it to be true for the purpose of my interim protection argument, because again, as I said, fairly I must assist this honorable court. Supreme Court says at the stage of bail, the court would not be at that juncture guided by, my lord, these allegations about age. While I have a case about age, which I will have to demonstrate later, at the stage of bail, it is my duty as a senior counsel to, my lord, tell your ladyships responsibly that at a bail, your ladyship will not be looking at whether the age is correct or not. At this stage, I have to satisfy your ladyship that even if the person is below 18 years of age, I am entitled to maybe grant of an anticipatory bail in future, because if I come to that threshold, only then your ladyship would consider granting me interim protection today. So, my lord, what this complaint therefore says is, the mother comes to know that June of last year, the daughter entered into a relationship. My lord, this is very important. Now, my lord, the mother says there was a relationship the daughter entered into in the June of last year. The mother then, my lord, refers to 4 incidents. My lord, one incident in the basement of their house, October, November, without giving a specific date. My lord, the second incident that they refer to is 25th October, which is in para 5, my lords. The third incident, my lord, they referred at page 17, again, my lord, the same para, is 13th November. My lord, ladyship may just note these 4 dates: October, November, 25th October, 13th November, and my lord, the most serious allegation they make is in relation to para 6, which is, my lord, on 31st December of last year.
Where is 13th November? I don't.
Yes, no, 13th November, page 17.
Yes, yes. And then 31st December.
31st December is at page 16. Lord, what I want to tell your ladyship is, in relation to each of these incidents I had indicated yesterday, that prior to and post each of these incidents, the daughter was in a very cordial relationship, my lord, with the accused. Messages would show, my lord, that they were exchanging these messages on a regular basis. There were telephone calls that stretched for 8 hours, 10 hours in one particular case. They spoke through the night. None of those messages will show that there was any issue relating to any part of the conduct. The ladyship may take it from me. The allegations are, my lord, of penetrative sexual assault. We are not accepting any of such allegations. Lord, my respectful submission is, though, my lord, we are taking that particular stand, when I have to seek interim protection, I must start with the complaint and say, even if the complaint is true, this would not be a case which would require me to be subjected to arrest immediately. Will not, with this background, if I may just show para 3 straight away. My lord, para 3 mentions, my lord, about a relationship starting. I'm sorry, para 2.
Yes.
June 2025, your ladyship will see that date in para 2. Para 3, my lord, mentions accused deliberately built trust with my daughter, induced her into a relationship. Lord, I just wanted your ladyship to mark that expression, into a relationship. My lord, then, after making allegations of continuous psychological control, including restricting her educational decisions, Lord, please mark the next expression, isolating her from independent choices. My lord, then para 4, my lord, makes further allegations that, my lord, he has sent messages from time to time expressing remorse and, my lord, expressing regrets for hurting her. Lord, I have gone through the messages to the extent I could trace. I could tell your ladyship clearly, my lord, that we will be able to show it to your ladyship. This is, my lord, in a relationship, my lord, when one person, they have a fight, if someone is fighting with some other person, if someone thinks they have hurt the other person, if someone is expressing hurt, my lord, expressing regrets for hurt caused, this is hurt caused emotionally in a relationship that happens, and your ladyship knows, my lord, this would not mean that any offense under POCSO is made out, nor would those messages indicate that this person expressing regret, my lord, in relation to the hurt caused would be determinative of any POCSO offense related conduct. My lord, then para 5, your ladyship saw, first paragraph refers to, my lord, the first incident. It says, my daughter disclosed it previously in my own apartment at the basement between October or November. He tried to, your ladyship may just read this part, but I just don't want to read this because that one sentence your ladyship may see, in spite of a resistance. Then, my lord, and on December, I'm sorry, on 25th October 25 at midnight, he took my daughter to Golf View Apartments located at Nanakramguda along with 2 other friends. But this is very important. There are 2 other persons, my lord, who were also present. And then, my lord, so and so, ladyship may see that next sentence. For a stay of 2 to 3 days. So, my lord, in the second incident, the allegation is the daughter was taken to stay with, my lord, my client for a period of 2 to 3 days. The ladyship will singularly notice, in those 2 to 3 days, my lord, the daughter did not take away the phone from the daughter, even according to the mother. The daughter was in free communication. She had her telephone and she chose to stay away for 2 to 3 days. My lord, next further. And my lord, the last sentence, your ladyship may notice on that particular part, force for so and so acts. Asking my daughter, my lord, next sentence, page 17. And then forced her, my lord, I'm not reading it, not that I'm omitting it. I'm requesting your ladyship to see the first line. Forced her for a sleepover despite her resistance. Sleepover, my lord, is when they go and stay at somebody else's house. My daughter faced similar incidents at so-and-so farm located at Moinabad dated 13th November 2025. Similar incidents, my lord, would obviously be with regard to whatever happened, my lord, on 25th October. My lord, then para 6. During this period, my daughter was taken to a private location, including residential premises and a farmhouse. And on 31st December 25, 1st January, Ananya Farms, Moinabad. I further wish to bring to your notice a serious incident that occurred on the night of 31st December 2025, continuing into the early hours of 1st January at a farmhouse located in Moinabad. On that occasion, my minor daughter was present along with so-and-so and his friends, consisting of approximately 5 boys and 2 girls. So, my lord, they were not alone. They were in the company of at least 7 other people. My lord, then, despite her resistance, my lord, ladyship may kindly see, She was pressured to consume alcohol breezer. My lord, what I would be doing is, my lord, if your lord ladyship would permit, because there's some material that I wanted to give to the police in the course of my aiding the investigation. There are video clips that have been taken by our friends, video clips that are present, which show, my lord, again, these are aspects I would have loved not to vilify the girl. Today, my lord, lordship may kindly take it from me. There is nothing I want to do any, my lord, character impugning or anything against the daughter. I am only trying to defend an allegation made against me that I forced her to drink a breezer. The videos, if your ladyship would see, not in your ladyship's chamber, because I do not want to show anything, she freely consumes alcohol on many occasions. And she is laughing. She is in fact trying, my lord, to give it to somebody else also. But then if I may read further. Thereafter, during the late night hours, approximately between 1:30 and 2:30 a.m., next part of that paragraph, my lord, I may just request your ladyship to see.
You can skip.
Yes, my lord. This is very important, my lord, because this would determine the nature of the offence in relation to which, my lord, the FIR comes to be booked. Because later on, 161 statement, my lord, they may have, because I don't have a copy of the 161 statement. There was an alteration memo.
You have the copy?
Yes, my lord. Yes, my lord. But all that I would want to say, my lord, for your ladyship's kind consideration is, taking each of these allegations to be, but for whatever worth they are to be true, then the offences that come to be registered are, my lord, aligning with these allegations. None of these allegations make any allegation, my lord, of any penetrative sexual assault my lord, in the complaint itself. Now, something is very important. My lord, 7 mentions, my lord, about severe distress and constitutes a severe act of coercion and exploitation of a minor. My lord, mental conditioning and dependency is mentioned. Next page, 8. She's, my lord, producing copies of the chat history and screenshots on record for the police to consider. My lord, then please see 9. On 7th January, my lord, this is very important. The accused abruptly terminated the relationship. My lord, please mark this. So he terminated the relationship and refused to take responsibility for his actions. I further submit that on 13th January, so-and-so contacted me through messages in a state of panic, expressing concern about her condition and requesting intervention. These communications reflect his awareness of the mental trauma and distress caused to my daughter and corroborate the impact of the above incident. My lord, I just pause with your ladyship's kind permission. 13th, my lord, they say that I contacted the mother, which is true. My lord, from 1st to, my lord, this date, my lord, the messages, my lord, that I will place for your ladyship's kind consideration, requesting ladyship to see would see that the daughter never complained anything till 7th. Then 7th, my lord, for whatever reasons they may have had, he decided to break the relationship, even according to the complaint. Post 7th, my lord, the boy started receiving messages about the girl threatening to commit suicide, sending pictures of Dettol, sending pictures of crocin, Dolo tablets she wanted to consume in a bulk. He was concerned. He called the mother and father and told them, this is what your daughter is doing. Please ensure that there is someone to protect her. Please reason with her. Tell her not to take any such actions. This continued, my lord, for a length of time. And my lord, eventually, if your ladyship sees, para 10, as a direct consequence of sustained abuse and abandonment, my daughter suffered severe emotional trauma, attempted self-harm on 19th January and 26th January. But what is important, my lord, your ladyship may note today, for the purpose of the complaint, for the purpose of interim protection, there has been no reporting of this, my lord, self-harm sought to be implicated, because your lordships are aware. If someone tries to inflict self-harm, which may cause danger to their life, it's actually an offence under IPC. No FIR registered. Then para 11. Subsequently, we received credible information that so-and-so has been circulating private and personal information of my daughter and spreading defamatory statements. Now, 12 is very important, because when your ladyship are looking at the complaint, normally what happens is a particular incident may happen. A lady will be very distressed. There may be a complaint filed on the next day. Maybe, my lord, the lady is in a state of shock. So what happens? The complaint may not have all the details. So, my lord, in the sexual offences, the court gives a slightly greater latitude. My lord, unlike other offences where any improvement is viewed, my lord, with a great deal of suspicion, in sexual offense related matters, my lord, the court gives a slight latitude where a quick statement following next day or any other day, my lord, the court will not discard it right away. But when your lordships are going to seek, my lord, from this complaint itself, that they, after becoming aware, and they're talking, my lord, the daughter trying to take serious steps in the month of January and February, they contemplated legal action. My lord, please see 12. When we initiated to seek legal remedy in March 2026, this is important, we began receiving calls and indirect pressure to withdraw the matter. But after this, my lord, they mention in para 13 that when they, again, last few lines, immediately after our attempts to seek legal remedy clearly indicates a concerted effort and criminal conspiracy to derail justice. My lord, then para 14, on 22nd April, my lord, they said someone tried to mediate a settlement. My lord, ladyship may see, my lord, they mentioned that they met and my lord, this causes some fear and intimidation with them. Para 15, I respectfully submit the entire sequence of events clearly discloses offences under POCSO, wherein consent of a minor is immaterial in law. My lord, please mark this. So they are now advised in law that consent of a minor is immaterial in law, which is also not correct in terms of law what it is. Along with serious offences under BNS including assault, criminal intimidation, defamation and conspiracy. Now, the reason I am pointing out this is, these are not words that come normally to a normal person. And it is very good that normal persons should learn about law, acquaint themselves well. All that I am trying to place for my ladyship's kind consideration is, they have now, because according to them, they were confronted with the problem, they started acquainting themselves with the legal steps. They were contemplating legal remedy in the month of March. My lord, and the usage of expression also, and them saying that consent is immaterial of a minor, my lord, indicates, my lord, that they have been now informed in law. Then 16, the Honorable Supreme Court has consistently held any sexual involvement with a minor, even under the guise of a relationship or promise of marriage. Lord, please mark this. Again, fully advised legally that the Supreme Court says if there is under a false pretext or a false promise, someone promises and the girl enters into a relationship, my lord, indicating today, even when your ladyships are posting the matter, my lord, for an anticipatory bail. But by the way, my lord, I am ready to argue my anticipatory bail today, but I am respectfully agreeing that your ladyship may want to hear the victim. So, my lord, I am only for interim. Arguments are going to be same, my lord, in any case. So, my lord, my respectful submission is, so when the person is now mentioning here that this is what Supreme Court has said, so by the time they are filing the complaint on 8th May, they have fully informed themselves about, my lord, all the legal areas of, my lord, the legal areas that operate in this area, what is their rights. And my lord, then please see 16. In view of the above, I humbly request your kind authority to initiate immediate action against so-and-so who also tried to false complaint against my daughter, and to provide appropriate protection provided to my daughter and our family to safeguard us from any further life threats in the interest of justice. I state the above facts are true to the best of my knowledge and belief. But again, these are expressions which normally used in an affidavit. So at this stage, my lord, your ladyship would notice that this would be a case where, my lord, they have been legally advised. My lord, why I stress so much on them being legally advised is, this complaint comes to be filed, your ladyship notes the date on 8th May.
Yes.
8th May, which is a full 4 months after he broke the relationship, a full 4 months, 8 days after the last incident, my lord. And after they come to know on 13th January, my lord, let me assume the daughter did not tell the, my lord, parents. The parents come to know on 13th January when, according to the complaint itself, I have written, my lord, to the mother and informed the mother. Post 13th January, no, they according to them, the daughter tried to inflict some harm on herself, my lord, January end and February. They don't file any report about that. But your ladyship can start with this assumption that by then they were fully aware of what happened. If they were aware and they took legal advice in the month of March and thereafter they file a complaint on 8th May, that 8th May complaint is a product of contemplation, reflection, legal information and, my lord, legal counsel, after which they are filing the complaint. Now, my lord, in this entire complaint, the ladyship will not find any allegation of any penetrative sexual assault. They have made allegations of sexual assault. So on the basis of this FIR, my lord, the police register an FIR and the police register the FIR, my lord, under these sections. My lord, may I just pass on this chart for your ladyship? Quick reference.
It is already filed, no, along page
Already
13.
filed. Yes. Now, this, my lord, I'm only indicating which offence is for what purpose and what extent. But in that first table, your ladyship puts 3.
74.
Everything, give copies to them. My lord, when the offence was registered, section 74, not less than 1 year may extend to 5 years. 75 BNS may extend to 3 years. Section 12 POCSO, my lord, may extend to 3 years. Offence, my lord, that comes to be added subsequently. My lord, now this is where, my lord, I have a gripe. My grievance is, unlike a regular case, my lord, where post-assault, my lord, complaint is filed the next day or the next day thereafter. And my lord, in a section 161 statement, and I said, my lord, there's a slight latitude only in sexual offence cases. Every other case, there is 0 latitude. Court will do it with great suspicion. But even if your ladyship want to give certain latitude to them, if such a complaint is filed, my lord, after so much of deliberation, contemplation and legal advice, referring to Supreme Court judgments, referring to consent being immaterial, referring to, my lord, the aspect that if you have taken consent under some deception, it is wrongful, but they would not miss out an important detail of penetrative sexual assault. No offence under that particular section is made out. So yesterday, my lord, I had made this argument for your ladyship's consideration. It can sometimes so happen that the complaint may attract a particular offence. But police, my lord, because they are not so well, because when they deal, my lord, no disrespect, my lord, they may have missed out adding a particular offence. But if your ladyships are going to be satisfied that from the complaint there is absolutely no allegation of penetrative sexual assault, and if the offences that are made are correctly recognized to be these offences which are all punishable under 7 years, I would have been straight away entitled to the benefit of Arnesh Kumar. Lord, I would have participated, I have assisted in the investigation, my lord, and the matters could have gone, my lord, in the way the law contemplates. Now, what they do is after they file this FIR, maybe if they thought, my lord, the notice of the FIR being given in the media would scare me and I would come around for, my lord, a settlement or whatever. If that did not happen, then they go and give a further statement. So the further statement given thereafter, my lord, in my respectful submission, is something that today,
Is the further statement voluntarily given or is it during the course of
161
statement.
161 statement. My lord, these improvements that are made in 161 statement, I'll place, my lord, 2 or 3 judgments for your ladyship's kind consideration. The court may view it with a great deal of suspicion. But I'm putting it at the highest. I'm not saying they should be discarded. At trial, my lord, what is the veracity to be given, your ladyship may consider. But if, my lord, the law in POCSO is not prohibiting the grant of an anticipatory bail. Now, this is something that will come into, my lord, the court's parameters of consideration, that if the original offence, which you are filing after 4.5 months, is not alleging any penetrative sexual assault, and if this is only providing for punishments below 7 years, can it be thought for a minute that the subsequent improvement, because by then you're already completely informed legally, a subsequent improvement, my lord, if it evokes any suspicion in your ladyship's mind, that I would respectfully pray, my lord, ladyship may have to grant me the benefit of doubt that there may be a possibility of an improvement for the limited purpose of an anticipatory bail today. Not because otherwise what it does is, it now straight away takes the category of offences from punishable below 5 years to 20 years or remainder of the remaining person's life. Please see the jump. There is a huge jump in terms of gravity that happens by way of an improvement. So that one improvement that is being done, why was this not mentioned on the day before? Especially if they have been contemplating legal steps from the month of March, especially if they are already aware of, my lord, various legal nuances in relation to a POCSO case. If they are so well aware, my lord, they would not have missed out this most important detail, and that in my respectful submission throws any amount of doubt, my lord, on their deliberate attempt to frame me in such a way that I cannot but be arrested, my lord, in this particular matter. So this may amount to, in my respectful submission, an abuse of process of law, and, my lord, trying to use the process of criminal justice for a purpose which is not intended. My lord, I am taking guidance, my lord, from your, my lord, several judgments that your ladyship, my lord, this honorable court and the Supreme Court has laid down in relation to SC/ST Act. SC/ST Act, there is a textual bar on grant of anticipatory bail. But, my lord, the courts have said look, if you are trying to ensure a person is coming under SC/ST Act for the purpose of preventing him to take an anticipatory bail, the court will look behind the complaint to see whether these incidents actually constitute that or not. But I am requesting your ladyship to give me that additional leeway into the court looking into only this additional section. But I am not arguing that the court needs to give me for the entire POCSO Act. But if the complaint given at page 16 is taken, I will concede section 11 and 12 of the POCSO Act are made out. But the improvement that is made, but in fact, if this improvement constituted a basis of the original complaint also, but I'm putting it slightly higher, my lord. Even if this improvement was a part of the original complaint, like in SC/ST Act, it's a part of the original complaint. If the court contemporaneous material, if the surrounding material excites a doubt in the mind of the court that this seems to be a contrivance for bringing it under SC/ST Act, the court says, no, we will disregard this because at this point, we will grant an anticipatory bail. So, my lord, today my respectful submission is, even if the improvement was originally a part of the complaint, if the contemporaneous, my lord, material at that particular point of time was going to raise a doubt in your ladyship's mind that this assault that they are talking is not correct, because the messages before and after, nothing is speaking about it. Even after, my lord, 6th January, nothing is speaking about it. I'm not, unless, my lord, the learned public prosecutor appearing for the police can place something else that I don't have access to right now. So, my lord, if I may now, therefore, my lord, make my point that the original complaint, all the offences correctly categorized. The improvement in what manner, I am not aware, but improvement is happening later after they have been legally counseled. So, the court may have to discard it for the purpose of interim bail. But there's a judgment, my lord, that I'll be placing very quickly. My lord, the court, while granting an anticipatory bail, tells us, my lord, when we are reading that judgment, my lord, when I say us is our lawyer community, this is not allowing someone to go scot-free. Anticipatory bail, my lord, is not like a quash. Your ladyships are not quashing the complaint. My lord, if your ladyships are otherwise persuaded by our argument, should your ladyship consider granting an anticipatory bail? Whether that improvement would actually stand up to trial, whether that sections need to be charged at the stage of framing of charges, my lord, all of that, there is a different journey. Unlike a quash, where, my lord, we would pray the court to quash the offence today. So, my lord, today we are not asking for quash, we are asking for a limited benefit to be granted to us in the case of anticipatory bail. My lord, this is my argument in relation to the complaint. What I want to do, my lord, is very quickly, because the ladyships have noted the 4 dates, but I am placing this in a sealed cover and giving it to my friends in a sealed cover. In fact, I must also seek a ladyship's permission. My lord, normally when we file these cases, we redact the names. In relation to some certificates that were filed, when we have to seek your ladyship's permission for redacting.
Yes.
But unfortunately, my lord, what happens is these days, I don't know how, the moment bail petition is filed, luckily, my lord, bail petition was filed without giving the prosecutor's name and the redaction. I'm told, my lord, this bail petition has been circulated in social media with underlying and analysis. Those certificates, my lord, if your ladyship's permit, I'll ask my colleagues to redact it, and the originals, my lord, or whatever certificates we may place in a sealed cover, which your ladyship can ask the registry to keep it in a sealed cover, so that, my lord, the victim's name does not come out. So, my lord, this.
I hope they have no objection to that.
My lord,
Court record, photocopies, these circulate just on social media. My pair baitik raavad then nothing.
my lord,
Application,
we are-
self-serving documents could be given and that could be used in a bail application. There is no such law. There cannot be, from the prosecution side, only the documents have to be looked into. Any document at this stage filed by the other side are actually not, they are not to be looked into.
No,
That's the
what
law.
he is saying is, these are not additional documents. Documents, I think.
Correct. Already
Along
filed.
with the bail.
Let
petition-
some of
No,
the-
what I understood, let him
Correct,
correct if I am
Ladyship's
also
are right.
the
In case if he is taken. into
The
custody or
documents
basically-
which are filed along with the bail petition, there are certain places where the names or name of the prosecutress have not been masked.
Strike.
They have done
It
it
is not
purposely.
masked.
They are liable for
So
prosecution
now,
for that, my lord.
that
Now
is-
at this stage, the court cannot accept those.
So he
They have
wants
come
to
out
now
clearly,
mask
my lord.
it
The
and give
passport-
other documents.
Well,
Well,
what I respectfully submit is the passport, her photograph is published, her names are published, the certificates, birth certificates, her names are published, and now they cannot then say that I want to take it back.
And now if we accept that, it amounts to, letting them go scot-free of the offences what they have committed.
So if they
It is
have-
a,
Let him
it's
argue at this
punishable
stage.
by 6 months.
Let him
Let
argue,
the
my lord,
prosecution take its own course. We are not willing to take that.
In respect of the date of birth certificate, other certificate, I collected from the IO, my lord. I may be permitted to
Why,
place.
sir, they are collecting my date of birth certificates? An application is given by the advocate to some other person, some Anthony Reddy and all. They say, we want to inquire. Who are you to inquire about my date of birth and date this thing?
Well, I-
It does it
I've
not
stayed-
amount
I've
to
stayed on
tampering
legal
with evidence?
My lord, I've stayed on
Register your
legal
objection
arguments.
to this.
Yes, my lord. Now, this is, my lord, the first, because, my lord, the complaint specifically refers to the messages that are being given to the police. And this is where I want to go and assist the police. My lord, your ladyship may kindly see. My lord, what I am placing is the chat between, I'm giving a copy to the learned public prosecutor. So, my lord, your ladyship would notice that whatever I am giving for your ladyship's kind consideration, and I will not read this. Ladyship would notice page 14. Your ladyship will notice the date, my lord, below the letter, just above the letter, 25th October. Your ladyship notices, my lord?
Yes.
Above 25th October is the previous chat. But I have not given the entire one, my lord, because I just wanted to focus on the dates that are forming part of the complaint. My lord, very important. Your ladyship sees on the left side above 25th October.
Yes.
My lord, like it happens, my lord, in WhatsApp, left side is what I receive.
Yes.
That is, my lord, this is the victim sending it to me. Right side is what I send. I had indicated yesterday for your ladyship's kind consideration. Left side on the top, there is a suggestion of a place now made by the victim. Because yesterday, my lord, the complaint I read to your ladyship to say that she was taken from place to place, indicating that she had no knowledge, and my lord, she was being taken forcibly. My lord, now please see next page. It's 26th October.
Yes.
This is after, my lord, that incident of 25th October, my lord. 25th October is one incident.
Hmm.
At the bottom left hand side,
Yes.
this is, my lord, movie tickets being sent by the girl because she wants to go for a movie with this boy. Next page also, page 16. This I am placing for ladyship's to consideration to show that if 25th October was the incident as alleged by the mother, my lord, then this does not align with the case of a person who, while being in a relationship, was forced to undergo any sexual harassment. But I am not even using the word penetrative sexual harassment. My lord, then please see next page. This is, my lord, everything that happens. I therefore said they were in a cordial friendship, stroke relationship, my lord, in terms of the complaint prior to one incident.
Hmm.
My lord, ladyship may only notice page number 18, right hand side bottom. But I'm not reading this out aloud. There's a quotation sent. My lord, next incident, my lord, if I may just place, is 13th November. Separate. Copies here. Now, this is a material I must give it to the police, my lord, for the purpose of assisting the police. My client just needs some interim protection so that he can go before the police and place all of this. Your ladyship has the date 12th November. My lord, in the middle of the page, below the
Yes.
photographs.
Yes.
Above that, my lord, are photographs which show that the family and the boy and the girl went to, my lord, some spiritual places together. Just below 12th November, your ladyship may see the time length. My lord, check. Another incident is 13th November, my lords. Page 17 top, your ladyship asked me, where is the date? 13th November. 13th November is the relevant date. Another incident. Now, 12th November, just below 12th November, left side, does my ladyship see
8 hours.
voice call 8 hours? This is call made from the girl's phone originally. It originates from the girl's phone. 13th November, voice call 6 hours. 13th November, they're talking normally for 6 hours. 8 minutes. Next page, your ladyship would see regular messaging, my lord, between people who may be in a relationship or friendship. Next page, 14th November, voice calls exchanged.
Yes.
14th November, my lord, is the third line. And your ladyship says 14th November, voice call 6 hours. Again voice calls, my lord, then messages are going on. Next page also, your ladyship would see all normal messages. So, my lord, 13th November, nothing for the, my lord, court to at this point glean that the incident of 13th November that is referred in the complaint, it may need to be investigated. I am only trying to place, because my lord, the complaint refers to social media chat. I am placing social media chat prior and after between these people, and my lord, this is between the victim and my lord, this particular person, that nothing from this chat indicates something serious. Maybe there is something more. That will be their case. Maybe a case for investigation. I am arguing this for the purpose of interim, my lord, anticipatory bail. My lord, next is 31st December. Copies wala good. Seal cover 11 number. But in fact, my lord, this 31st December, there are other messages which show that they were planning a 31st December get together with friends for a long time earlier. And my lord, the places were being suggested by all people. We'll go to this place, that place, not that she was forcibly taken as the mother tried to complain. Now, Lord Ladyship sees 30th December.
28th.
30. My lord. Page 5.
Yes.
Which number? Third set. My lady has been on?
Yes.
My lord, ladyship sees on 30th December, what is forwarded by the boy to the girl is Telangana Excise Department giving permission. But Excise Department, your ladyship knows, the permission is if they want to have a small private party if they are consuming liquor. Now, then please see next page.
Yes.
No, I'm sorry, same page below, 3rd January, your ladyship sees there are missed calls. When she calls, not picked up. We don't know what transpired, what was the fight or whatever. Next page, regular, some forwards of messages on 5th January. Left side, my lord, something that the girl sends, the photographs. Next page, again, 5th January, my lord, photographs of something else. At the bottom of the page, but again, typically, my lord, in a friendship, because the mother calls it a relationship and I don't know them as well, but I'm only, even if I take the allegation to be true, but please see page 9. I think the problem starts, my lord, after the missed calls start happening from here. 7th January, the mother admits relationship broke off. But 31st December, 1st January, the nature of allegations made, which my lord in the original complaint were at the nature of sexual harassment, lord, nothing of that nature reflected from lord, the contemporaneous surrounding circumstances. And this is a test your ladyship not has laid down in the SC/ST case, that even if the complaint were to make, in this case, had the original complaint made an allegation about penetrative sexual assault, which is section my lord 5 and 6. Even then, if there is something for the court to see that this may be something that is just added for the purpose of spicing up the complaint, the court can look behind. Luckily for me, but I have a much lesser burden to discharge, because if I take the allegation entirely, post proper legal advice, post them contemplating legal action from March, filing the complaint in the month of May, 8th May, if they have not made that, that in my respectful submission singularly entitles me to the grant of a limited benefit of doubt for the purpose of anticipatory bail. Your ladyships are not deciding the issue, your ladyships are not discarding the improvement, your ladyships are not saying that no case is made out. As long as the court thinks that this is a matter where if I need to be taken into custody, that is the original sections required me to take into custody, it's a different issue. They did not require me to take into custody. So any improvement made, as I said, my lord, the normal latitude may not be available in this case, because the original complaint is filed, as I use the expression, my lord, with full contemplation, full deliberation, full legal advice, my lord, and your ladyship may see the language, my lord. It would have done me proud. Honestly, my lord, I'm not trying to demean it. It's a very well drafted legal complaint, which clearly emanates, my lord, from some very good legal advice they have taken. So if someone who's so legally well advised uses, my lord, the nature of language which I'm complimenting them, that is not making this allegation, any allegation made thereafter may be incorrect. Lastly, my lord, very quickly now I have to show some law and then I'll conclude, my lord. My lord, your ladyship may kindly have, my lord, POCSO Act. My lord, the object of this act itself.
Yes.
My lord, this was pursuant to the Convention on the Rights of Child. My lord, the last para of that act. And whereas the state parties to the Convention on the Rights of the Child are required to undertake all appropriate national, bilateral and multilateral measures to prevent, my lord, A, the inducement or coercion of a child to engage in any, my lord, please mark this, unlawful sexual activity. My lord, original object was not any sexual activity, unlawful sexual activity. The exploitative use of children in prostitution or other unlawful sexual practices, the exploitative use of children in pornographic performances and materials. My lord, then the definitions, my lord, I'll skip. My lord, what may be relevant though for your ladyships to note would be 2A, which is aggravated penetrative sexual assault. D becomes relevant, my lord, because under the Indian context now, we have defined the word child to be any person below the age of 18 years. Now, this has but however come up, my lord, for judicial consideration. My lord, then your ladyship may see the original sections were 11 and 12. Your ladyship may kindly go to section 8. 7 is, my lord, sexual assault. 8 is punishment for sexual assault. 3 years and extends to 5 years.
Yes.
11, my lord, is sexual harassment. 12 is punishment for sexual harassment, which may extend to 3 years and shall be liable to fine. The improvement, my lord, they tried to bring it is under 5, which is aggravated penetrative sexual assault.
Yes.
But I have not been privy to what they are saying. So in the original complaint, not even in relation to the 4 incidents, single incident alleged of penetrative sexual assault. Now for it to come under an aggravated penetrative sexual assault, while I am still in the blind about how they try to attract this section, my lord, it will require something more egregious. My lord, it may be under, my lord, KLMN, I don't know. My lord, the learned public prosecutor will tell your lordships how, my lord, that improvement brought it under this. My lord, K is whoever taking advantage of child's mental or physical disability commits, my lord, penetrative sexual assault, may not apply in my case, my lord, in my assessment. 11, whoever commits penetrative sexual assault on the child more than once or repeatedly. But as I said, as I see the complaint, there is not even once. So now 6 is the punishment, which extends to 20 years or remainder of natural life. My lord, after this act, my lord, was made, your ladyship says this was in 2012. My lord, there was, my lord, Justice Verma Commission that was constituted, which dealt with this. My lord, I am showing these two very quickly, my lord, before I go to the judgments, my lord, that I want to rely upon. My lord, Justice Verma Committee in 2013, my lord, said that they recommended, my lord, that this must be brought down to the age of 16 on the supposition that after the children cross the age of 16, they will have slightly greater maturity. And my lord, therefore, this POCSO offences, my lord, must be brought to, instead of 18, that must be brought down to 16. But I must fairly state, as I stated in the beginning as a senior counsel, I must bring it to your ladyship's notice that this has not been accepted. But the Law Commission also recommends that this has to be brought down to the age of 16. But what I will now place for your ladyship's kind consideration is, even with the act being what it is, just give me that Verma Commission. Which prop note is it?
No, but it has not been accepted. So
not been accepted. So, but I'm not there. But with the act being what it is, but the matters have come up for consideration before the court. But I am placing 2 or 3 judgments for your ladyship's consideration, and that will conclude my arguments. First, my lord, the my lord, High Court. Please can you give me this judgment? Bombay High Court. Vijay Chand. Lord, there are many judgments, but I just want to trouble your leadership with only 2 today.
you have filed copies here along with
But
this
I am just giving
compilation,
this.
or-
No, my lord, no, my lord. That was only on the aspect of a ladyship's power, the court's power to grant. This is the Bombay High Court judgment. And the ladyship sees, provisions of POCSO Act, were also coming up for consideration. Para 2, 363, 376, Section 4, Section 8 of POCSO. Then from Para 8 onwards, 7 onwards, I'm sorry.
Yes.
Insofar as the offences punishable under 4, 6 and 8 of POCSO Act are concerned, it may be stated that the provisions of this law, though stringent in nature, would not deter the court to grant or refuse bail in order to secure the ends of justice. The conduct of the prosecution in this case is indicative of the fact that she left, should be prosecutrix, that she left her home without informing her parents by her own will, and also stayed with the applicant for 4 days. No doubt that the prosecutrix under the purview of POCSO is a minor. However, the facts of the present case indicate that she had sufficient knowledge and capacity to know the full import of her actions and what she was doing, and had only thereafter voluntarily joined and stayed with the applicant for 4 days. Attention is drawn to the decision of Justice Ms. Mrudula Bhatkar in the case of Sunil Mahadev Patil to contend that the consensus of the prosecutrix who is below the age of 18 years is a mitigating circumstance for trial court to consider it. In furtherance to the above, the court has laid down certain specific guidelines after taking into consideration relevant case and also the ethos and development of the age of the young offenders in the Indian society in general. Court in Para 8, 9, 11 and 12 has laid down certain principles. The quoted portion start at the foot of the page. Next page, my lord. Second line.
Yes.
If a girl is a minor between the age group of 15 to 18 years, and if it can be safely inferred that her consent was obvious, then it is a mitigating circumstance. Some trial courts dealing with such bail applications, especially after Nirbhaya, started taking a strict approach, and the accused are denied the bail only on the ground that the prosecutrix being minor below 18 years, her consent is immaterial. Therefore, the case of rape on such minor, no bail can be granted. This is a matter of concern. In view of the increasing offences against the women, especially of rape, the legislature both found it obligatory to deal with those offences with severe punishment, and women can be protected if the laws are made rigorous. Therefore, the report of Justice Verma committee was accepted, and necessary and significant amendments were made in these two sections. A wrongdoer is to be punished, guilty is to be convicted. However, this is important, at the stage of bail, the court has to consider prima facie under what circumstances the offence is committed by the accused. In the criminal law, the court cannot ignore the intention or motive behind the act, and that is an important factor in the commission of offence, so also to decide the quantum of sentence at the end of trial. So in the case of bail. Today, teenagers are exposed to more sex-related issues, and lot of material is also available to them to know the sexual relationship between a man and a woman. Because of their impressionable age, girls and boys both may tend to get provoked, and there may be a curious and very compelling demand of the body to get into such kind of relationship. Sexual urge differs from person to person, and there cannot be any mathematical formula in relation to sexual behavioral pattern of teenagers, as biologically whenever the child turns into puberty, the child starts understanding his or her sexual needs. The nature of response depends on the upbringing, peer pressure, how civilized the environment is. Sex requires proper physical and emotional preparation, as it results in many physical and emotional consequences. This is all considered as sexual maturation. Therefore, some sets with view to regularize sexual behavior of the community have acknowledged this biological factor, and therefore the early age marriages are performed in some religions or communities. Taking into consideration the social and biological factors, the lawmaker have considered the age of 15 as an age of consent when marriage is performed. Taking into consideration this background, the trial judge has to pass an order of bail in such cases. The overall circumstances while dealing such applications can be summarized thus. When a boy and a minor girl are in love with each other and chose to live together without the consent of their parents, then the following factors are to be considered. 1. What is the age of the prosecutrix who is minor? Not the difference between a 14-year-old, 13-year-old versus a 16, 17-year-old. Whether the act is violent or not. 3rd, whether there are antecedents or not. 4, whether the offender is capable of repeating act or not. 5, whether there is likelihood of threats or intimidation if at all the boy is released. 6, whether any chance of tampering with the material witnesses when their statements are recorded. It is also to be taken into account in such cases that a boy in his early 20s deserves to get employment and to plan, stabilize and secure his future. So proceeds on the predication that the boy may not be minor. he may be little above 20, then 9. Insofar as the present case is concerned, it is seen that the victim has left her parents' house without informing the parents, stayed with the applicant for 3 days and 3 nights, and also she confessed she was in love with the applicant and travelled along with him to different places. 10 is the last para. It is settled law that a court, while deciding a bail application, has to keep in mind the principal rule of bail, which is to ascertain whether the accused is likely to appear before the court for trial. There are other broad parameters also, like gravity of offence, likelihood of accused repeating the offence while on bail, whether he would influence the witnesses and tamper with the evidence. These are the regular parameters. But I am only trying to bring it to my lady's kind notice, but that some of the most stellar judgments, in fact, have been rendered by ladyships of different high courts. This quoted part is also by one of the ladyships who adorns the high court bench. The next judgment that I am placing for your ladyship's kind consideration is Delhi High Court, which is Ajay Kumar's case, only for the limited purpose of bail. Para 4. In my opinion, the intention of POCSO was to protect children below the age of 18 years from sexual exploitation. It was never meant to criminalize consensual romantic relationships between young adults. However, this has to be seen from facts and circumstances of each case. There might be cases where survivor of sexual offence may be under pressure or trauma be forced to settle. Then para 5 refers to a Madras High Court judgment. 6 is the Dharmender Singh judgment, which I am reserving, where the High Court, several other High Courts have taken presumption at this place cannot be placed until charges are framed. Then 10. Thus, this is not a case where the girl was coerced into a relationship with the boy. In fact, Miss So-and-so herself went to the applicant's house and asked him to marry her. The statement of the victim makes it clear that this is a romantic relationship between the two, and the sexual act involved between them was consensual. There was in fact no dispute also. In my case, my lord, this needs to be, because the lordship saw there is absolutely nothing in the complaint. Then if I may read further, although the victim is minor and hence her consent does not have any legal bearing, I am of the opinion that the factum of a consensual relationship born out of love should be consideration while granting bail. To ignore the statement of the victim and let the accused suffer behind jail in the present case would otherwise amount to perversity. 11. I am cognizant of the fact that the proceedings before me, this is what I wanted to place, is for grant of bail, not of quashing of FIR. It is not a case where the slate of the applicant is wiped clear. In the circumstance of the present case, the applicant is entitled to bail for the reasons enumerated below. Then last judgment that I want to place for your ladyship's kind consideration is of the Andhra High Court. Andhra 10. Yes, 2024. Her ladyship of the Andhra Pradesh High Court. This arose in the context of a regular bail because there the arrest happened, but the same principles would apply for the anticipatory bail would be my respectful submission. Para 7, the ladyship may only notice there, my lord, the petitioner was 21 years and the victim girl is 16 years 5 months. My lord, then next para 8. Recently, a coordinate bench of Delhi High Court. This is a different judgment from which I placed. Mahesh Kumar. That is quoted Delhi High Court. The prosecutrix and the accused herein might have made a mistake in the affairs of the heart. However, the teenage psychology and adolescent love cannot be controlled by the courts, and therefore the judge has to be careful while rejecting or granting bail in such cases, depending on the facts and circumstances of each case. This court also observes that the attitude towards early love relationships, especially adolescent love, has to be scrutinized in the backdrop of their real life situations to understand their actions in a given situation. The teenagers who try to imitate romantic culture of movies and novels remain unaware about the laws and the age of consent. Well, then Bhagwan Singh judgment is cited. If I may just invite my ladyship's attention to page para 11.
Yes.
Coming to the case on hand, the victim girl is a minor. Her consent is of no value in the eyes of law. According to her, she was in love and she voluntarily left with the accused, married, had physical intimacy. In the peculiar circumstances of the case, it's clear that after consuming poison, the victim called the accused and informed him that her family was against her wish to marry him. The conduct of the accused, as seen from the complaint, is vivid, that on coming to know that a case was lodged against him, he dropped the girl at her parents' house, which would indicate that his intention was not otherwise dangerous. The complaint would further show after studying class 9, the girl dropped out and was staying at her house. The age of the girl is subject matter of a full-length trial now. But why I refer to this particular paragraph is, your ladyship sees 7th is according to the complaint itself, the relationship broke. 13th, the boy calls the mother, informs the mother, calls the father, informs the father, please ensure no danger is done to the daughter, protect her because she is threatening to commit suicide, take necessary steps. Assuming that this call, and it was made, my lord, because the messages would bear this out and investigation would reveal more details. It would show the conduct of, my lord, this person, that he had no intention of trying to do something, run away, to wash off his responsibilities. I've placed, my lord, only some part of the conversations that happened. Now, your ladyship also sees the conduct of the prosecutrix. But from the chat, limited chat, and I didn't want to place more, my lord, because this matter is being heard everywhere. And maybe, my lord, the next date, or there may not be a next date in this case, but whenever anything we have to do, we'll try to request the court to do it in camera. But my respectful submission is, the conduct of the prosecutrix, if she, my lord, was in a position where, my lord, she was going out, meeting people, staying for 3-4 days, nothing wrong, my lord, because parents trust their children, they give the children, my lord, the freedom. And we, my lord, when we do that, we trust the children only after we feel they are capable of taking some independent decisions. But I am not making any allegations, my lord, I just want to be very clear. I am saying that even according to the parents, when they are allowing the child to go out for 3 nights, 4 nights, 2 nights, they trust the child and they know the best. They are the best judges. I am now, my lord, relying on the parents' judgment of the child's maturity, where they think the girl can go and stay out for 2 nights, 3 nights, or 4 nights. But if the parents have sufficient confidence in the maturity of the girl, and the girl is not lesser than 17 years, my lord, even according to their own case, if the girl, my lord, was in a relationship which the complaint refers, and if the relationship ends in a breakup as the complaint says, and if the complaint thereafter says that this breakup, my lord, her ending into a relationship was induced by a false promise of marriage, it may be a case of cheating, not penetrative sexual assault, my lord, under POCSO. Lord, in fact, I must, yes, my lord. So, my lord, my respectful submission is, in the totality of these circumstances, where the law itself, A, did not prohibit the grant of anticipatory bail, B, my lord, if the facts and circumstances, and I have placed several orders of the Supreme Court granting interim protection which have been confirmed, under section 6, and my lord, where there are several other judgments of the court, my lord, Law Commission's report, my lord, I am not referring to the recommendations, but I just want to place it where the Law Commission refers to various high courts lamenting, my lord, this wrong application of POCSO. I am not even using the word misusing. And Law Commission therefore recommends. So, my lord, the recommendation may not have been accepted, law may not have been amended, but the Law Commission noting that several courts across, my lord, and the several courts, as I mentioned, my lord, would be Madras High Court, Kerala High Court, my lord, Karnataka High Court, Madras, I mentioned Madras High Court, my lord, Allahabad High Court, Bombay High Court, my lord, Guwahati High Court. I have all these judgments. Where not the courts have lamented, I just need to show the Law Commission recommendation with regard to the High Court speaking of.
They are all not necessary for.
Very well. So, my lord, my respectful submission is, this is a matter that may require investigation. I am not asking for quash. I am only praying for grant of anticipatory bail. But if anticipatory bail is granted, I will readily go join investigation, assist. If suppose after my assistance, after deeper investigation, but it is eventually found that I have to be found guilty of some offense, the punishment would follow. But suppose if I am taken into custody and eventually if I am able to show, my lord, that this is maybe, my lord, an incorrect application of POCSO being applied against me, particularly, my lord, those more graver sections, then my detention being caused, my lord, will become irreversible and it will be harmful. So, my lord, my respectful submission to your ladyship's kind consideration is, in the facts of this case alone, in the circumstances of this case alone, taking the complaint as was drafted with full legal advice, no serious offense was originally made out. 161 statements, my lord, that may have been recorded. The learned PP may assist your lordships, but your ladyships may take it that whatever they are saying post 8th May would be for the purpose of trying to frame me in a more strong sense that I'll come under the threat of. And my lord, they have a grievance. They have a motive to improve and punish me because they feel wronged. The ladyship sees the complaint itself, they feel wrong. So they have a motive, my lord, trying to go after me. If your ladyships are able to see that, my lord, I would respectfully pray that anticipatory will be granted to my client. Any conditions, my lord, last submission I'm making, even if, my lord, in like in some cases, my lord, court directs, my lord, that there must be some reports made to the court monitored investigation, my lord, by any condition where I have to go and appear on almost on an everyday basis, my lord, let me do it. Let me give any assistance they may need. I am fully willing to subject myself, my lord, to this investigation. I just need, my lord, to ensure that I am protected for the purpose of going and appearing and giving everything that they need, because this is a false case filed against me. But I am deeply.
My lord,
Anybody a diabetic here?
my lord,
Huh?
my lord, I got the instruction, my lord. My land senior counsel yesterday argument, today argument, my lord, is seeking the my lord, anticipatory bail in POCSO case. Definitely is not entitled. My lord, kindly see, my lord. My lord, my land counsel, my lord, submitted before this honorable court. Improvement is there, my lord, nothing. Even first complaint, my lord, victim daughter, my lord, victim, my lord, mother also filed the complaint on 8/5. Even, my lord, page 17, my lord, kindly see complaint, my lord. All, my
But,
land.
he read out in total.
Yes, skip, my lord, where he was skipped the land council, skipped the word. It only 4 lines without my lord reading. Kindly go through the, my lord, even attract the, my lord, 5 and 6 POCSO Act. Page 17, my lord. My land friend skipped the words in order to.
Para 6.
Yes, my lord. Para 6 last 4 lines. My lord, definitely, my lord, it attract the, my lord, 5 and 6 POCSO Act. Apart from that, my lord, my instructions would be.
No, you say that 5 and 6 are attracted there.
Yes, my lord.
What is 5?
Even first complaint itself. My what I want to, my lord, even 161.
And then if it attracted, then why did you not add it?
My lord, even
Why did you
my land friend time and again saying that it is an improvement. My lord,
No,
adding the,
initially, okay, let it not be
my lord, even
improvement.
161 statement.
When you are saying that, these recitations in para 6.
Even my humble
attracts for 5 and 6. You should have added.
Even words, my lord, even my lord, FIR is not an encyclopedia. My lord, IO having the power to, my lord, either delete the, my lord, accused or added the accused, my lord, he is having the absolute power. My lord, subsequently, after, my lord, taken into, my lord, statements from the victim itself, then, my lord, added the section of law.
Okay. Now, what is that statement which
My lord,
you
kindly
need to
see.
add?
My lord, victim statement, my lord, page number 15, 14, my lord.
This is the mother of the victim.
16, my lord, 16 and 19.
14.
9th, my lord, 9/5/2026 was recorded by the, my lord, sub-inspector. Yesterday, my land friend stated before this honorable court, my lord, IPS officer, lady IPS, not at all correct. Only sub-inspector, my lord, 16, my lord. Lordship got it, my lord. May I permit to read out?
Yes.
నేను బాధితురాలని పరిచయం చేసుకుని ఏం జరిగిందని అడగగా మా తల్లిదండ్రులకు ఇద్దరం సంతానము.
You can leave out all those things and
My lord,
come to the
even-
relevant portions.
Even narrated the, my lord, in detail, my lord, apart from the her mother complaint.
Yeah.
My lord, even middle, my lord, only మా తల్లిదండ్రులకు హైదరాబాద్కు వచ్చి సుచిత్రాలో సోన్సో నందు ఉన్నాము. నేను 10వ తరగతి వరకు డిఆర్ఎస్ నందు కోంపల్లో చదువుకున్నాను. తర్వాత ఇంటర్మీడియట్ నిర్మల్లో ఓపెన్ యూనివర్సిటీ నందు ఆర్ట్స్ హెచ్ఈసి తీసుకొని చదువుకుంటున్నాను. తర్వాత జూన్ 2025లో లోకేశ్వరరావు అనే ఫ్రెండ్ ద్వారా పరిచయం అయ్యాడు. జూన్లో నాకు సోన్సో నా సస్పెక్ట్ యొక్క అకౌంట్కు బండి సోన్సో పర్సన్ 23 years స్టూడెంట్ సోన్సో అనే వ్యక్తి నాకు ఫ్రెండ్గా రిక్వెస్ట్ పంపించినాడు. నేను బండి సోన్సో పెట్టిన ఫ్రెండ్కు రిక్వెస్ట్ నాకు హౌ హీ వాజ్ ఇంట్రడ్యూస్డ్, మిలాడ్ he was narrated. Milord, kindly see next, Milord, in order to save the
This
time.
is not in dispute at all that there was friendship or relationship or introduction,
Milord,
that is not in dispute at all.
According to
So let us leave-
my humble submission,
Come
according
to-
to first complaint, according to second complaint, definitely the contents Milord mentioned by the victim, there absolutely there is a Milord penetrative sexual is there.
come to that portion
Milord.
or whatever you think relevant, just about her
Yes, Milord.
introduction about herself and all that may not be relevant there. That's what I'd say.
Milord,
ఇద్దరము మా యొక్క కామన్ ఫ్రెండ్స్ తో కలిసి రెస్టారెంట్ కఫే
page number 17 Milord, concerned para,
ఎస్
middle Milord,
ఐ థింక్ హియర్ ఆల్సో
page number 17, 161 statement, Milord, in respect of victim girl, page 17, Lordship got it? Middle.
you should read
13th
the
November
last-
2025.
You should read the last lines of page 16 also.
ఎస్ మిలట్, నాకు తెలియకుండా ఎక్కడికి వెళ్ళొద్దని, నా నా ఫ్రెండ్ను కూడా కలవద్దని రిక్వెస్ట్ చేసేవాడు,
రెస్ట్రిక్ట్ చేసేది.
రెస్పెక్ట్ చేసేవాడు. తర్వాత గోల్డ్ పేజ్ అపార్ట్మెంట్ కి నానక్రామ్గూడ ఎయిర్ బ్యాండ్ ఏపీపీ ద్వారా సోన్సో అపార్ట్మెంట్ ను అక్టోబర్ 2025 నాడు డబుల్ బెడ్రూమ్ అపార్ట్మెంట్ బుక్ చేశాడు. తర్వాత అదే రోజు నేను సోన్సో మోక్షలం కలిసి వెళ్ళినాము. తర్వాత మేము కలిసి పార్టీ చేసుకున్నాము. ఆ రోజు సోన్సో ఐఎమ్ స్కిప్పింగ్ ది నేమ్ తీసుకున్నాడు. అదే మత్తులో అర్ధరాత్రి నా దగ్గరకు వచ్చి నా యొక్క నెక్ పట్టుకొని నా నెక్కును సోన్సో అన్నాడు. తర్వాత
not read this.
yes
You are reading this.
Milord, kindly see Milord, next Milord. Of course Milord, there is a clear word see there. Milord, 13 middle Milord, 13th November 2025. Next after 5-6 lines. 13th November 2025, మా పేరెంట్స్ లేరని తెలుసుకొని, Lordship got it? Middle Milord, same page 17, same page, left hand side, 13th November 2025.
Left hand side. Yes.
13th November 2025, మా పేరెంట్స్ లేరని తెలుసుకొని మనము స్లీప్ ఓవర్కి వెళ్దామా అని అడిగినాడు. నేను వద్దు, మనం ఇద్దరమే అని అనగా, లేదు మనతో సోన్సో కూడా వస్తారని చెప్పి మా ఇంటి దగ్గరకి వచ్చి నన్ను తీసుకొని లక్స్ ఫామ్ హౌస్ తీసుకుని వెళ్ళినాడు. అక్కడ నాకు అర్ధరాత్రి ఆల్కహాల్ కలిపిన డ్రింక్ కు నాకు బలవంతంగా ఇచ్చాడు. అతను కూడా ఆల్కహాల్ సేవించి నా యొక్క సోన్సో చేసినాడు. నన్ను కూడా Milord, this is the all the she's narrated everything Milord. Milord, reason for skipping Milord, it is not fair to read the open court Milord, all these things.
No need of reading. Yes.
Yes Milord, next also Milord.
So this is the statement of the girl on what
Yes
date?
Milord,
On what date?
Milord,
It is on
9th Milord, 9/5/2026 Milord, recorded. Milord, next page Milord, 60, page number 20.
Yes.
Milord, after recording the statement from the victim, Milord, section of memo was filed Milord, same was altered. Milord, kindly see page 21 Milord.
Yes.
Page 21 Milord reflects Milord, initially she was studied Milord, victim girl studied 1 to 6th class at Bahimsa Milord, 1 to 6th class Milord. According to the 21 Milord, disclosed that her age Milord, 12/8/2010, right hand side Milord.
Yes.
Milord,
So
Page
10th
20
class SSC memo also shows
yes
the
I
same
Milord,
date.
I filed Milord, page 22 Milord.
Oh, but SSC certificate shows something else.
Yes Milord, there is a 2 dates are there Milord. Finally Milord, according to investigation Milord, 12/8/2008 Milord, 8 is the correct. Milord, page number 24 kindly Milord, the 10th class memo Milord, marks memo,
12/8/2008 is the correct one.
8 correct. Reason would be Milord, the IO Milord inquired with the date of birth certificate, kindly see 25 Milord. Date of birth certificate given by the GHMC Hyderabad. Milord, she was given a birth at Perenda's Hospital, Hyderabad.
Hmm.
Our IO Millard went to the Perenda's Hospital and verified the record, and it is found to be correct. So finally, Millard, her date of birth 12th August 2008.
Yes.
Therefore, Millard is
So even if it is taken 12th August 2008, she's still a minor?
yes, yes, Millard, yes, Millard. Millard,
What would be her age?
now as on today, Millard, 7.
As on the date of, we will take it in 31st December.
17 years, 3 months, Millard. 17 years.
17 years, 3 months and 15 days.
17 years. and 3
The
months.
last date of.
Yes.
But 2 dates are there. Whatever the dates taken, Millard, even 2008 correct date of birth taken also, Millard, she is a minor. Therefore, Millard, is a POCSO Act. Millard is not entitled to get any bail, Millard. Therefore, it should be dismissed. My humble submission.
Yes.
May it please your lordship. Well, two strong points were raised by them, my lord. The first and the foremost was, my lord, POSCO would not get attracted as a victim is not a minor as defined under the said act. The second point what they raised was that, my lord, assuming even POSCO gets attracted, section 5(1) punishable under section 6 has no application, as the sections which are applicable are all punishable with less than 7 years, which have been originally registered in the FIR, and thus is entitled to a notice under section 35(3) of the BNSS, my lord, which is equal to 41A of the old act, I mean the Cr.P.C. And then interim protection, which now they are not claiming, my lord. So in my written arguments, my lord, I've just mentioned, which I'll pass it on as a brief note I've made.
He has argued the criminal,
No,
both
we are, that's what, my lord, we have, my learned friend said that he wants to argue the anticipated bail application. So therefore, even I agreed that we will conclude it today itself. There is no point now further postponing it. And I don't want to go into the technicalities of that, my lord, and waste the precious time of this honorable court. My lord, as far